Further hearing in the appeal, Reyes against Malki and another.
Sorry, jumped the gun. Sorry.
Before the break yesterday, I was addressing the second of my 8 heads, the alleged commercial nature of trafficking. And I was addressing what we understood to be the appellant's written case, namely that one can or one should perform a fact-finding exercise to ascertain whether there is a commercial activity. And in that regard, one needs to look into the background circumstances of the contract to determine, for example, whether sub-market wages were paid. And I'd been setting out why we say that cannot be the correct approach. And I'd made 3 points up until the break. My third point was, as noted by Lord Dyson in the Court of Appeal at paragraph 34, the proposed approach would result in manifest uncertainty. Moving on, my fourth reason is this as to why that approach cannot be correct. There has not actually been any factual inquiry in this case as to whether, for example, sub-market wages were paid, whether there was any other actual financial gain. And at least on the written case proposed approach, we say that that must be fatal to the case.
On your point about sub-market wages, I thought it was pretty clear from the first letter that Reynolds Porter ever wrote, enclosing a cheque for £1,000, that they accepted that no wages had been paid.
Well, my lord, that is a separate point as from whether the original agreement was or was not sub-market. As to the point about whether there was a breach in the terms of payment, I'm going to come on to that, if I may, in a moment.
Well. Surely the real question is, given the hypothetical basis on which we, in the absence of findings, have to decide this case, is whether, assuming that sub-market wages were paid, that makes it a commercial activity.
Well, again, I'm going to come on to that because that's the case that was, as we understand, focused on in the oral submission, that one makes a series of assumptions.
It seems to matter.
Well, my lord, can I finish on addressing the fact-finding case and then come on to the assumptions case?
But we know no facts were found at all. I mean, the whole case is put on the basis of assumed facts.
What we've said, the question is which facts is it legitimate to assume for the purpose of construing this exception in this international treaty? And as Sir Daniel said, one can assume the allegations in the statement of case, but it does not follow from that one can assume the allegations of trafficking. And I'm going to come on to that under my third head of submission. And nor does it follow, I say, that one can assume the alleged financial benefit.
If we don't make that assumption, we are not actually deciding the issue of principle which justifies the appearance of this case before us in the first place. The question is, all of this will have to be proved, if this was a trafficking case, what difference does that make in law to the answer to the vital question, was this a commercial or professional activity?
Well, Lord, we say, and I'll come on to this in my third head, but that is one of the fallacies in the appellant's position. None of this will ever be proved because there is no actual allegation of trafficking in the claim. Even if they succeed on every single allegation they make, all they will prove are the elements of an ordinary employment claim. There will be no finding, for example, of deception. There will be no finding that the respondents acted for the purposes of exploitation. And I'll come on to that. We will say that that's why one can't make that next leap to assuming trafficking.
So are you saying that for present purposes the trafficking allegation is irrelevant because it isn't pleaded?
Well, I'll come on to that. I will say that one have to look at the appellant's case. The appellant's case is that this is an employment relationship that meets the international definition of trafficking, and that the respondents were the perpetrators of the trafficking.
And that has to be judged purely on the pleaded facts?
Yes, that's essentially what we will be saying.
Right. When you say essentially, that's a bit of a weasel word. Are you saying one can go outside the pleaded facts or not?
We're saying no, you cannot go outside the pleaded facts.
Well,
So
Even if
we
there's some evidential material in support of it, you couldn't look at it because it's not in a pleading, you're saying? Or what? You have to look at the thing more broadly than that, surely.
Well, I will again. I was planning to go through all of these points
Okay.
in order. So, if I may, can I come back to the question of the evidence? So, coming back to the written case, the fact-finding case, and this,
I mean, I really object to fact-finding cases because there haven't been any facts found.
my lord, we have
Never
said.
been any founding, except in an entirely different tribunal, which is, I think, not relied upon for the fact-finding.
if as a matter of pleading, how does it work? Is it that the statement of claim is put in if the defendant wants to rely on diplomatic immunity? Is it something that has to be dealt with in the statement of claim, or is it a strikeout point, or is it raised as a defence? What's the appropriate pleading?
Well, in the employment case, in this case, as I understand, and I will correct me if I'm wrong, it was dealt with as a preliminary issue.
Well, it has to be, doesn't
Yes.
it?
Yes.
Because if the immunity exists, then the court has no jurisdiction to find facts or make any decision at all.
Exactly.
So we surely are in the position where we have to ask, does the immunity exist in all the circumstances which appear to obtain not simply the cause of action, but any relevant background? Now, you may be right in saying that legally parts of the background are irrelevant, but we can't simply falsify the question that we're asking ourselves by leaving out some of the facts that may be material and decide it on a partial basis.
I mean, as I see it, what would happen is, normally, I can't speak about an employment tribunal, and I'm not out of date in normal litigation, but a claim would be put in court, in the court, in a claim form with a full pleading. The defendant wants to claim diplomatic immunity. They would raise it as a strikeout issue or a preliminary issue. They'd put in evidence in support in a witness statement. And then the claimant would reply to that, saying why diplomatic immunity didn't apply, which suggests to me that the issue is not simply be determined on the pleaded case, but by reference to all the evidence the parties choose to put in, because it would be determined as a preliminary point. That's why I'm asking this rather dry question, because that's how one would expect it to be determined. Is that wrong?
No, and that must be right also in a general case
Well,
outside of the employment tribunal.
If it's right, then coming back to Lord Clark's question, why are we limited to the facts in the statement of claim?
May I come back to that?
Okay, if you want to,
my third
okay.
amendment? Can I deal in relation to Lord Clark's question about the other evidence that's in play? Because, for example, we have the determination by the UKVI that the appellant had been found to be a victim of trafficking.
Yeah.
And bearing in mind, this court has to approach not just the facts of this case, but as a general matter, the court has to be wary of adopting an approach that would make this whole international treaty unworkable. And the appellant says, this is paragraph 25(4) of its written case, in relation to the question of commercial activity, it effectively said, look, it doesn't matter that there's not been any determination or any evidence as to commercial activity in this case, precisely because they say, and I'm quoting, the competent authority has adopted a set of accepted indicators of trafficking, which could be expected to provide a ready guide for a court in addressing all material questions. Moreover, the competent authority aims to make a conclusive decision within 45 days, a determination that the Crown Court would ordinarily abide by, absent evidence to the contrary. And they refer to paragraph 25 of their submissions, which cites the case of RVL. And I would like just to break down those elements to illustrate that relying on the UKVI determination would make this treaty unworkable. First point is this. The UK VI determination, which was at CV2 MS 775, does not give any reasoning at all. It merely states that the appellant has been found to be trafficked. It does not even state the respondents were perpetrators, and it says nothing whatsoever about financial gain sub-market wages, or anything that goes to commercial activity. Furthermore, in this regard, it seems it is actually the standing practice not to provide minutes of reasons to the victim of trafficking. The reference for that is the UK Competent Authority Guide at Authorities 34, MS 1929. And the reason seems to be that the underlying reasons are subject to data protection, and that's MS 1972. So even if this document is deployed, it begs the question, what on earth is the diplomat supposed to do with it? What is the diplomat supposed to be responding to? Secondly, the appellant's point about a 45-day target is simply wrong. In this case, the determination of the UKVI occurred in January 2014. That's almost 2.5 years after, that is 2.5 years after the employment claim was commenced in June 2011. Furthermore, it is factually erroneous for the appellant to say there is a 45-day target for a decision. We think that is based on a misreading of the competent authority guidance. What the guidance says is, and I'll give the references in a moment, it says there will be a reasonable grounds decision, which they aim to do within about 5 days of the initial referral. There will then be a 45-day recovery and reflection period, and thereafter, the word is after, there will be a conclusive determination. The references for that are M34, MS 1923, and MS 1879. 1923 says in terms there is no target. And as we see in this case, it took 2.5 years. The next point is, as mentioned yesterday, the determination is not legally binding on the respondent. The case of RVL does not take matters further. That case is at the authorities tab 79. And there are two reasons why it doesn't take any matters further. The first is the relevant paragraph is paragraph 28, which is MS 2888.
Which bundle?
This is bundle M6, authority 6, bundle 79. The context of this case was not a civil claim for compensation. It was a criminal case, and the question as to the relevance of these UKVI determinations arose in relation to the following question, which is where there is a defendant who has been found to be a victim of trafficking by UKVI, but the fact of that determination was not taken into account in decisions to prosecute or in convictions, what is the approach, the correct approach to take? And the court said, well, if the crime with which the defendant is accused was integral to or consequent upon the trafficking, then there would be grounds under the abusive process jurisdiction to quash the conviction. And that is at MS 2877 to 2878. The key point is paragraph 28 at 2888, which is at the end of that paragraph. The court, talking about the determination, says, although the court is not bound by the decision, unless there is evidence to contradict it or significant evidence that was not considered, it is likely that the criminal courts will abide by it. Now, this is a case where there is no evidence from the respondent, so it would be a case of significant evidence not being considered. Moreover, it's not a case where it's being said in a civil context, one can bind two parties to a claim. It's a criminal context where the alleged traffickers were not parties.
But where,
After you.
I was going to, where are we actually going? I'm sorry, I'm not.
Well, I'm responding to the appellant's submission that these UKVI determinations can generally be binding upon a court.
I don't think that that's...
I don't understand that to have been... Ms. Doherty, perhaps you could...
No, my lord, we refer to these at paragraph 25.4 of our printed case, really for the purpose of showing no more than that our allegations are not frivolous.
Yes, well, that's what I thought, yeah.
Well, I'm grateful for that. I won't
I'm sorry, Lord Wilson had a question too, I'm sorry.
Well, it was rather along the same lines. I don't think this is helping us. We would conventionally deal with this issue on assumed facts. Occasionally we might say, well, the facts alleged here are really so inherently contradictory or unlikely that we're not sure we want to proceed on the basis of assumed facts. And Mr. Otti is really deploying the UKVI determinations to show that one couldn't possibly have that particular doubt about deploying the ordinary procedure of proceeding on facts which have not been found against your clients.
I think the position that I'd understood Mr. Otti to say precisely what he just said, namely that it was to bolster or protect his position against what Lord Wilson has indicated, which is a suggestion that the claims were fanciful. That was all.
Lord, we see all of that. And perhaps I can come back to this under my third head. But if the approach that is required here is that the appellant puts in evidence outside the pleaded case of allegations of trafficking, in a diplomatic immunity context, the problem that creates is, first, a diplomat has an immunity from giving evidence, which is 31.
But again, I don't see where this gets you, because the truth is that if there was an allegation of commercial, what undoubtedly was commercial business, a commercial activity, and the diplomat wanted to deny it, he'd have to put an evidence, the court would still have to decide. So this is a problem, as I think Sir Daniel accepted, which is inherent in the system. The fact that it's a problem doesn't really help. It's inherent in where there's a dispute about whether you fall within a particular provision. So what? I mean, your problem would arise, wouldn't it, in a perfectly straightforward case where they said that Mr. Al-Maliki had set up a business of, I don't know, advising people on investments and was charging people, and he denied it. They would give evidence, and you'd be in the position you describe. It's inherent in the system.
My lord, that situation may arise where the pleaded claim makes those allegations, and then those allegations will be assumed for the purpose of determining immunity. The distinction in our case is there is nothing about trafficking in the pleading.
That is the distinction. There's nothing about trafficking. But nonetheless, the point you make is inherent in the system, isn't it? In our judicial system, our court system meeting up with the diplomatic immunity point. I mean, it might be pleaded that there was a contract, and you want to deny it. The claimant would in due course give evidence there was a contract. You'd have to decide, or your ambassador would have to decide whether you could give evidence against it.
But my lord, the distinction is this. If there was a pleading of a contract, we would assume on the basis that that plea was correct, and the immunity.
Yeah, but the problem would come at some point, wouldn't it? That you would have to choose whether to give evidence or not to say there wasn't a contract.
But the distinction...
And the contract, if Mr. Daniel's right about the one-off point, a single contract wouldn't be evidence of carrying on business. You would then say, well, all right, I did enter into this contract, but I didn't carry on business generally. That would then be an affidavit or witness statement evidence outside the pleadings, and the issue you identify would come about. Surely it's inherent.
Again, I come back to the same point. The distinction is there is no actual... whilst we're content...
No, in the example I've given, that wouldn't be in the pleading either. The claimant would say he gave me the investment advice, it was and charged for it, it was negligent. You would say I've got diplomatic immunity and this was a one-off activity, and therefore I'm not caught because Sir Daniel says it's got to be a continuous activity. There'd then be an argument about that. And that mightn't be in the pleadings, it might be in the affidavit evidence. wouldn't be part of the claimant's case.
My Lord,
Only
I'll
be
come
part
out.
of the diplomatic immunity issue. So it seems to me it's inherent in the way the thing works, whether in relation to this or any other case.
Can I come back to on my third head? But we do say simply going down that route is a very dangerous approach.
I see the point, but as I say, it's inherent as I see it.
Coming back to what the oral case, which is based on to Mr. Otti's oral case, based on assumptions. What we understand the commercial activities case to be of the appellant and where it rested in the oral submissions was this. First of all, one assumes the facts in the pleading for determining the question of immunity, and we've said we're content to adopt that approach.
Right.
Second, even though the pleading itself says nothing about trafficking, you go further and you assume the trafficking from the pleading. Thus, you assume the deception from an allegation of breach of promise, even though there's no plea of deception. You assume that there was, for example, recruitment for the purposes of exploitation, even though there's no allegation of exploitation or that the respondents acted for any purpose. And in that regard, the deception and the exploitation are, we understand, to be assumed from the allegation of breach. And then the next assumption you make is you assume there is a financial gain to the respondent as a person at the end of the trafficking chain. The financial gain, we understand, again, is to be inferred from the allegations of breach. So we understand what is being said is, well, if there was a breach of a non-payment of wage, if there was if a breach of the duties as to employment conditions, then that is the financial gain. And there are, we say, a number of problems with that approach. First, the test for ascertaining a commercial activity, as Sir Daniel submitted yesterday, is whether there was a commercial activity for profit. And just as a matter of language, the idea that a breach of contract can give a financial gain and that is the relevant profit, that is not the correct approach to this treaty.
This submission assumes that one imports from Article 42 to Article 31(1)(c) the requirement that it should be for with profit. Do you also have a submission on the footing that you don't do that?
Yes, we do. But yes, absolutely, you're absolutely right. That is on that assumption. Second, and I'll come on to this, we dispute the legitimacy of assuming trafficking. But thirdly, and this is the key point, this approach of assumption after assumption after assumption would make the treaty unworkable, because it would allow somebody to come along and say, well, and even putting to one side the for-profit point, assuming that against us, it would allow a party to say, well, I entered a contract, the contract was breached, you assume the breach in my favour for the purpose of establishing immunity, you assume, therefore, that the respondent made a financial gain for the purpose of commercial activity, and therefore the commercial activity exception applies. Because in reality, that whole argument, that whole construct of assumptions boils down to saying you assume the breach of contract, that yields the financial gain, and that financial gain yields the commercial activity. That would mean that the 31(1)(c) exception would apply not just in ordinary employment contracts, but potentially in any claim for any breach of contract. And just to summarise under this second head, all these points that I've made are not technical points. If Sir Daniel's submissions are correct, that an ordinary employment relationship is not within the 31(1)(c) exception, then at that point, to nevertheless allow a claim against a diplomat to proceed would put the UK in breach of its international obligations. So there has to be a clear principled basis for nevertheless bringing in these assertions of commercial activity, of trafficking. And also, the approach the court takes must be one that does not render this treaty unworkable. So in summary, the correct approach to commercial activity is this. First, as Lord Dyson said, the question of whether there is a commercial activity as a matter of language cannot be construed by reference to investigation of background circumstance. Second, the question, and this is the for-profit point, is whether there's a commercial activity for profit. That is our primary case. And we say the appellant's approach does not meet that threshold, that test. But thirdly, whether it's for profit or just a commercial activity, again, adopting Lord Dyson's formula at para 34 of his judgment, as a matter of ordinary language, the question of whether there is a commercial activity must be judged based on what the employee is employed to do. I'm not dealing, for the avoidance of doubt, I'm not dealing here with the question of official functions. I'm simply dealing with the approach the court should take to determining whether, as a matter of ordinary language, there is a commercial activity. And to go down the route the appellant urges upon this court would open up this exception, would make it unworkable. Perhaps put another way, what we're saying is this. It's the question for the court is not really which facts should the court assume, it's which facts are the relevant facts for the purposes of determining whether there is a commercial activity. And given all the considerations I've set out, we say the relevant fact is, as a matter of ordinary language, what is it that the employee is employed to do? The relevant question is not what is the alleged breach. Taking an example, for example, from the prop end case, in that case, the question of commercial activity and indeed official functions was not assessed by reference to whether the breach of an undertaking was a commercial or professional activity. The question was assessed by reference to whether the giving of an undertaking by a police officer stroke diplomat was a commercial activity. That's my second head of submission. The third head is a point that we've already debated to some extent, which is whether this is a claim that relates to trafficking. And we have said we're prepared to assume the facts alleged in the pleading, but we say it will be wrong both in principle and as a matter of the practice of this treaty to go further and to assume the trafficking. And we say that for the following reasons. The first is a very simple point. The claims are not for trafficking. I also, in this regard, this first simple point, refer to the reasoning of Mr. Justice Langstaff in our case in the Employment Appeals Tribunal. That's at paragraph 54 to 55 of that judgment, which is at CV2 MS 655, where essentially what he says is you look at the claims are not for trafficking. And he goes further and he says this: immunity really is a plea that claims which would otherwise be within the jurisdiction of the employment tribunal, so in our case, ordinary employment claims, are not within the jurisdiction of the employment tribunal because immunity applies. And what he said was it would then be odd if you could go further and say, but nevertheless, the immunity is defeated by claims, in this case trafficking, that would never be within the jurisdiction of the employment tribunal. The second point is this. We say that the question whether the claim relates to trafficking is the wrong question. On the appellant's case, the relevant question is this: was this an action relating to, quote, an employment relationship whose elements meet the international definition of trafficking in which the respondents were perpetrators. To look at to address the very broad question that they put misses the target, because their case is this was an employment relationship under the international definition and the respondents were the perpetrators. So the question is whether the court can proceed on that basis, not on some general basis as to whether there is some general trafficking out there.
I mean, the argument against you is that you look at the elements of trafficking as defined in the Palermo Protocol and the Anti-Trafficking Convention. Then you look at the elements of these employment claims, and where you find a substantial consonance between the two, you have got, for this purpose, an allegation of trafficking. Now, that was the approach in Hunger. You're about to come on to it.
Yes.
And I would, if Hunger is wrong, we must understand that and correct it. So don't pull your punches when you come on to that, as I think you're about to do.
I'm grateful, my lord. Well, I am about to come on to that. Before I address Hunger directly, I want to make my third point, which is leading on exactly from what Lord Wilson said. My point is this: the approach of discerning the elements of the international definition from the statement of case would mean that trafficking could be discerned or asserted in pretty, well, I won't say literally any employment claim, but perhaps the vast majority of employment claims. And that is, when one does the analysis, one sees that. So the first element, actually it may be helpful in this regard to turn to Miss Reyes' written case at paragraphs 7 to 8, which is CV1.
Yep, 127, yep,
Yeah.
yep.
So we have three elements to that international definition. The first is action.
Yes,
So recruitment, I'll look at the words that are underlined: recruitment, harbouring, or receipt. Now, as we understand it, that is said to be discerned merely from the allegation of a contractual relationship. But there's nothing else we can see in that statement of case that gets one to recruitment, harbouring, or receipt. On almost any claim, there's going to be some allegation of the existence of a contract. The next element is means.
yes,
So means of deception, that we understand is their main case. And then they talk about abuse of power or of a position of vulnerability. Again, none of those words are pleaded. So
Well, those are different things. I mean, you've mentioned deception, and I wondered whether to pick you up on it, because to my mind, it's the by means of abuse of power or of a position of vulnerability, which is more obviously engaged here.
your point is not so much what's engaged here, but if you look at the various components of alternative components of means, like alternative components of action, you wouldn't have much difficulty in having at least an arguable case on the pleadings for saying many cases fall within it. That's your point, isn't it?
That's exactly my point.
Well, we got that point.
Yeah.
Yep. Yep. So we turn to exploitation.
Yeah, so means is said to be inferred from the breaches. There's always going to be allegations of breach. And for the purpose of exploitation, there's no expressed allegation there was any action for any particular purpose. Again, that's just said to be inferred from the allegations of breach. So precisely as Lord Neuberger has said, we have the scenario of many, perhaps the vast majority of employment claims being susceptible to this kind of construct, and that's what it is, a construct. But that's my third point here, unworkable. Fourthly, Mr. Otti referred, I think in the alternative, to the indicators of trafficking. He said, and this is also what the Court of Appeal said, that the indicators of trafficking are pleaded in the statement of case. We say that doesn't really help because, just as a matter of principle, if the case is the elements of the international definition are made out, it's not at all clear why, for that purpose, it's enough to point to indicators of trafficking. Surely, even assuming everything else against me, at the very least, one has to point to the statement of case and identify the actual elements, not these secondary matters which give rise to yet further inferences. It's also important to understand exactly what these indicators are. Could we please just turn to the Miss Reyes referral form, which is at CV2 751.
Yeah.
This is the form that was sent to the UKVI that resulted in the determination, and this we see on the first page the names and so on, and then over the page this is 752 through to 753. There's a series of questions. There's general indicators, indicators of forced labour, domestic servitude, and so on. And the applicant ticks various boxes. So the submission I'm making here is, lest there be any misunderstanding, this is not a case where there are 10 definitive indicators, and if those are satisfied, that means there's trafficking. Rather, the origin of the 10 indicators is, as I understand, it's this form. There's a number of these indicators. The applicant can tick them. Over the page, then, the applicant can give a more detailed description of her circumstances. And then we go to the reasonable grounds determination. This is not the final determination. This was the initial reasonable grounds at the 5th of May. This is page 756 to 757. At 758 to 759, we see there's a narrative. And then at 760, we see the 10 indicators that Mr. Otti is talking about. So what's happened here is there's been a reasonable ground determination that the elements of trafficking are satisfied, and then it's by reference to picking the 10 indicators, which broadly correspond to the 10 indicators that were ticked. So ultimately, there's no hard and fast test. That's my point. If there's not just a checklist, if these 10 follow, that gets you to the inferences.
Yeah.
And moreover, the reasonable grounds threshold, even accepting these 10 factors, is not that under the UKVI system, is not that trafficking has been proved. It's merely there is a suspicion of trafficking.
Yeah, we've got that.
Yeah.
Yeah.
So again, we say that an alternative approach, looking for indicators from a statement of claim, A, misses the target, and B, has exactly the same problem of unworkability. One can see claims being constructed that would carefully plead some indicators, and then someone will say, well, there's trafficking, and the court has to assume there's trafficking, and that means we now have to lift the immunity.
Well, of course, you can have false claims.
But you can also have evidence, interlocutory evidence, to refute them.
Well, that's one of the problems with this, because we're looking at the context of immunity, and it's not just that the diplomat has an immunity from giving evidence that would have to be weighed, but as a matter of principle, and this is a point made in the jurisdictional immunities case, so paragraph 82, immunities need to be determined at the outset before facts are determined. And there's a reason of principle for that. The ICJ said in jurisdictional immunities, immunity is not just immunity from jurisdiction, it's immunity from the trial process. And so an approach that says, well...
It's not an immunity from the process of deciding whether an immunity exists. And that may need evidence.
It does seem to me rather a difficult submission to accept, which is what this amounts to, which is this, that if we otherwise think that this activity is within the exception in 31(1)(c), we should say it isn't, because it would lead to procedural difficulties. a pretty extraordinary submission, isn't it?
Well, my
Because
point-
if it isn't in 31(1)(c), you don't need this submission. If it is, I find it rather difficult to accept we should say it isn't, because it'll lead to procedural difficulties, which is what this submission really amounts to.
Well, we say no, it's more than procedural difficulties. It's contrary to the essence of immunity, and it's an immunity from the trial
But
process.
you must accept, I'm sorry to sound like a scratch record, but you must accept that there will be cases where the question of immunity turns on facts that have to be determined. Yes?
Well, we accept one can assume the facts in the pleading
Well,
to the
well, so in this case, it does amount to this, that if all the facts which are relied on to support the trafficking allegation had been pleaded, then we would be having this argument. Let's say they realised you were going to rely on diplomatic immunity, so they put all these points in their pleading. What then?
Well, my lord, with respect, that would be an artificial assumption, because there would simply be no justifiable legal basis for in an employment claim pleading the elements of trafficking, for saying there was
That may
trafficking.
suggest that what's in the pleading is not the critical factor. Because we're not concerned here with what issues might arise at a trial. We're concerned with the question whether there should be a trial. And that may require us to either assume or find certain facts. Unless you're submitting that the convention means that nothing which is inherently disputable should ever be relevant in deciding on the effect of the convention.
Well, perhaps an alternative form, that is my submission, because we say, looking at the question of commercial activity, that has to be determined, as Lord Dyson says, by looking on the face of the matter at what the employee is employed to do. And that is a matter that will either be accepted, as it is in this case, or will be the subject to an assumption in terms of what the assumption as to what is pleaded.
Not even that can necessarily be right. Let's say that Mr. Malki is running an employment business for household employees, and part of what he does is to take them on for 3 weeks at a time to train them up. But nonetheless, he trains them basically by making them work for him. Now, that may well be a commercial activity, may it not? Employing them in those circumstances, part of his employing them in those circumstances could be part of his business. On the face of it, he's employing them for 3 weeks in his house. But it may be part of a training program, because that's what he does as part of the exercise of training people for his business, so they become good servants, good employees. And one would have to look at those facts, if they were alleged, to see if they were true.
But in that case, one will still be coming back to the test of what is it the employee is employed to do.
Well, the question is not whether the employee, in pursuing his employment, is engaged in a commercial activity, but whether the employer, in employing him, is doing so.
Well, can I come back to the submission I was trying to make, which is the approach of trying to assume trafficking from a statement of case would render the treaty unworkable. That's my submission. And can I go further, and perhaps this might be an answer to these questions of assumption, and why, as a matter of principle, we say it is that one cannot, whilst it's legitimate to assume the pleaded facts, in this context, the allegation of trafficking, as a matter of principle, it's not legitimate to assume the trafficking. And it's this: the appellant's case is breach. The appellant's case is that to allow, or rather to uphold the immunity, would be an actual breach of Article 15.3 of the Anti-Trafficking Convention. That is the point put, various points in writing, that was the point put orally. And in order for there to be a breach,
I thought it was said yesterday that the appellant was no longer, on your part, the appellant was no longer alleging breach, merely alleging that the trafficking dimension was an aid to the construction of, or part of the construction of Article 31(1)(c).
Well, I'd understood that in order to deploy Article 15.3 as an aid to construction, it is still being said that if the immunity is upheld, then Article 15.3 would be breached. And if that's not what's being said, then we're not really clear how Article 15.3 comes into this at all, because even in Haunger, the point the court made was that in the circumstances of that case, there was a breach, or there would be a breach of Article 15.3 if the illegality defence was upheld. And perhaps that's the answer of principle to the court's concerns, where we say prima facie the employment relationship does not come within Article 15, within Article 31(1)(c), and Mr. Otti says no. I can rely on trafficking, I can do so on the authority of Haunger, and I can do so because to do otherwise would be a breach of Article 15.3. That's where, as a matter of principle, it becomes problematic to then say, but I can assume all the elements of my breach. He can assume the elements of his statements of case, but that's not enough. Now, fifthly, I would like to come on to Haunger. And we say this: it does not assist the court in this case for the following reasons. First, Haunger was based on a particular construction of Article 15.3 of the Anti-Trafficking Convention. However, as I and Sir Daniel have said previously, the short point is Article 15.3 does not apply to Saudi Arabia. Second, Haunger was a completely different case to the present one. It was a case about identifying the content of UK public policy in the context of the assertion of a substantive defence of illegality. It was in that context, i.e. trying to discern the content of UK public policy, that the majority in Haunger said that Article 15.3 should be given an expansive meaning to extend not just to claims for trafficking, but claims for employment. Haunger was not an authority on Article 31(1) of the VCDR. It did not establish that for the purposes of Article 31(1)(c), an ordinary employment claim, which makes no allegation of trafficking, can somehow be treated as relating to trafficking. Third, nor was Haunger obviously about immunity. It did not establish that Article 15.3 requires the exercise of jurisdiction where immunity might otherwise apply. And fourthly, and this is just looking at the approach of the majority, Haunger does not support the approach of assuming the trafficking, which Mr. Otti argues for. The key point is this: in Haunger, the majority determined, or were prepared to determine, or proceed on the basis there was trafficking, following a full trial on the facts in the employment tribunal. That was because Haunger was not an immunity case. It came to the court after a trial and on issues of illegality. The findings included, for example, this is Haunger paragraph 15 at MS 1275, that the employer had attacked and beaten the employee. And it was in the light of the findings of fact that the majority was prepared to go further and say, well, there would be trafficking, or rather, that, strictly speaking, what they said was applying the indicators of trafficking. The matter is so, based on these findings of fact, the matter is so close to trafficking as to make no difference. That's the fourth point. The fifth point is, in Hangen, the majority inferred the trafficking not by applying the international definition, action, means, purposes of exploitation. They did so by looking at a couple of the ILO indicators of trafficking. And it's not at all clear why, as a matter of principle, two ILO indicators should allow a determination that the elements of the international definition are met, that they are different things. And on this, I do refer to the approach of the minority, who said that, I think this is paragraph 65, who said, when you're trying to determine trafficking, even on the basis of findings of fact, you've got to apply the international definition. So they expressed misgivings about the idea that you could simply infer for the purposes of exploitation. They noted there had been no finding of any purposes. And finally, and we set this out in our written case, we do dispute the decision of the majority that Article 15.3 should be given this expansive meaning to extend to employment cases. We simply say that's not what Article 15 says. Trafficking and employment claims are not coterminous. We do make that point, but I also emphasize we don't need to win on that point to overcome Haunger. Against that background, can I now come to my fourth head, which is the common law interpretation approach. We addressed this in our written case at paragraphs 94 to 98, and we say this. The appellant argues under common law interpretation that there is a strong presumption in favour of interpreting English law in a way which does not place the UK in breach of an international obligation. And it says, it follows from that the appellant is entitled to bring into play Article 15.3 and to apply it against Article 31.1c of the VCDR. Well, the answer to that submission is as follows. First, the correct common law approach is the one Sir Daniel outlined in Fothergill. This is the case of a domestic statute that gives force of law to an international treaty. As Fothergill set out, the correct approach is an international approach in accordance with the Vienna Convention on the Law of Treaties. Neither of the cases cited by the appellant changes that. The appellant cites the case of Lyons and indeed Haunger itself as somehow going against Fothergill, but the simple point is neither of those cases involved the approach to be taken to a domestic statute that gives force of law to an international treaty, and the comments about the strong presumption in both of those cases were made in a very different context. Second, there is no basis in law for using the Anti-Trafficking Convention to read down the VCDR obligation. The short point is the one we keep coming back to. The ATC does not apply to Saudi Arabia. So even applying the appellant's strong presumption of not breaching the UK's international obligations, their approach would do precisely that, because it would seek to apply a treaty to Saudi Arabia, to which Saudi Arabia is not party. It's accepted there's no superior rule of law in Article 15.3 of the ATC that would allow, under orthodox principles, an immunity to be overcome. And as I said earlier, applying the approach earlier yesterday, in jurisdictional immunities and Jones and Saudi Arabia, it is conceptually flawed even to try and construe immunity, which goes to the procedural matter of jurisdiction, against substantive obligations, such as Article 15.3 of the ATC, and the references to the analysis of jurisdictional immunities and so on is at paragraphs 23 to 24 of our printed case. And finally, Article 15.3 says nothing at all about immunities. So taking the appellant's case at its highest, Article 15.3 is ambiguous. I also refer back to what I said about Haunger and us not accepting the majority's reasoning in Haunger as to the construction of 15.3. At its very highest, 15.3 is itself ambiguous, and there is no reason to try and force an ambiguous provision to read down Article 31(1)(c). 15.3 itself must be read in accordance with international law, which includes the principles of immunity. That's the second reason, the second broad reason. The third point is this, and it relates to the Palermo Protocol. Perhaps in an attempt to overcome the problems about the Anti-Trafficking Convention, particularly the fact that the ATC does not apply to Saudi Arabia, Mr. Otti mentions the Palermo Protocol. It has to be said that it is only mentioned very tentatively in the written case. It appears just in a footnote. It's footnote 40 of the appellant's case. Yeah. And the appellant says, in addition to Article 15.3 of the Anti-Trafficking Convention, it is to be noted that Article 6.6 of the Palermo Protocol would be breached if, on the assumed facts, Miss Reyes' claim was dismissed for lack of jurisdiction, since it would mean she could not obtain compensation for damage suffered. We deal with the Palermo Protocol at paragraph 88 of our case, that's MS 225.
Thank you.
But the headline points are these. The text of the Palermo Protocol is different to 15.3. The Palermo Protocol talks about each state ensuring that its domestic legal system contains measures that offer victims of trafficking in persons the possibility of obtaining compensation for damages suffered. The text of Article 6.6 is closer not to Article 15.3 of the Anti-Trafficking Convention, but Article 15.4, which talks about imposing legislative or other measures. In other words, there is no reference to a right of victims to compensation from the perpetrators. There is a Council of Europe explanatory report in relation to Article 15.4, which says that Article 15.4 is directed not at rights of victims to tort claims, but at matters such as compensation schemes. And that explanatory report is in Bundle 3 of the authorities. It's at the back, and it's paragraphs 197 to 198 of the report. So our submission is that Article 6.6 of the Palermo Protocol does not relate to private law actions for damages. It relates to matters such as state schemes of compensation. That was the reasoning and decision of the minority in Haunger and Allen. That's paragraph 65 of Haunger, Authorities Bundle 9, MS 1292. And that decision is not contrary to the majority because the majority did not consider the Palermo Protocol. The majority only considered the Anti-Trafficking Convention. The position we take was also supported by the Court of Appeal, in this case, paragraph 45 of the Court of Appeal judgment, so where it says Article 6 of the Palermo Protocol merely requires a legal system to offer a possibility of compensation, does not describe the means, and, for example, a criminal injuries compensation scheme would appear to suffice. So we say 6.6 clearly does not assist. But then again, at the very highest, 6.6 is no more than ambiguous. We say it's clear based on the majority in Haunger, based on the Court of Appeal. But even if that's not right, it's no more than ambiguous. And again, there's no reason why an ambiguous provision, which says nothing about immunity, nothing about rights of compensation against perpetrators, nothing about tort claims, nothing about jurisdiction, should be used to prise open the provisions of 31(1)(c). Harmonious interpretation would certainly not require such a result. The fifth interpretive provision, or the fifth heading of my submissions, is the Human Rights Act. And this is the fifth head of my submissions. It's addressing the second of the appellant's interpretive approaches. The appellant said this, it's, both in its written case and as amplified by Mr. Otter yesterday. It says that the obligation of interpretation required by Section 3 of the Human Rights Act is mandatory and cannot be avoided by reference to the international context of the Diplomatic Privileges Act or asserted international law obligations of Saudi Arabia. So what they seem to be saying is it doesn't matter if ultimately the court adopts an approach that puts the UK in breach of its international law obligations. That is required by the Section 3 obligation. We say that's not right. First, the basic approach is the Fothergill approach. Give this an international meaning in accordance with VCLT. Second, there are well-established limits on the principles and on the scope of Section 3, which we summarise in paragraph 99 of our document, that's MS 229. And they include, for example, the court must not interpret a provision in a way which goes against the grain or the substance of the legislation in question. In this case, the very purpose of the Diplomatic Privileges Act is to give effect to the UK's international obligations under the VCDR. It would go against the grain of that legislation to adopt a meaning that knowingly puts the UK in breach of those obligations. Fourthly, the appellant has not actually pointed to any authority in which a UK court has decided that even though its interpretation puts the UK in breach of its international obligations, nevertheless, it will go down that route because Section 3 requires it to do so. Finally, the European Convention itself exists in international law and itself must be interpreted in accordance with the Vienna Convention on the law of treaties. That was the position as a matter of international law, as a matter of domestic law, in the judgment of Lord Kerr in the Muhan case that Sir Daniel mentioned yesterday. But that is also the jurisprudence of the European Court of Human Rights itself in relation to the two rights that the appellant seeks to invoke. As I will come on to show, in relation to both Articles 4 and 6, the court always emphasises that the ECHR itself is part of international law and must be interpreted in accordance with that. Accordingly, it would be somewhat perverse to then applying Articles 4 and 6 to find a conclusion that puts the UK in breach of its international law obligations. So that's dealing with Section 3 under the Human Rights Act point. The appellant had another argument under this heading. The appellant says that, and this is actually quite a prominent feature of the appellant's case, that under European Convention on Human Rights jurisprudence, there is an obligation to construe an ambiguous international measure in the manner that best secures compliance with fundamental rights. That is put at paragraphs 82 to 85 of the appellant's written case. And that proposition is said to be based on three judgments, starting out with the case of Al-Jeddah and leading to the recent judgment in Al-Dumali. We say that is wrong. First, as the Court of Appeal held in paragraph 62 to 63, none of those cases involved immunity. But moreover, none of those three cases established the broad proposition that the appellant contends for. All three of those cases concerned not treaties, but the interpretation of UN Security Council resolutions. And the court's statement about construing those resolutions in accordance with fundamental rights was limited to the context of Security Council resolutions and was expressly based not on any general principle about international measures, but on the particular context of the UN Charter, which defines one of the roles of the UN as being promoting human rights. There was no general broad proposition, as the appellant suggests. And can I just illustrate that by briefly going to those cases? The first case is Al-Jeddah, which is at M898 MS3612. This case, the issue was as follows. It was whether the internment of Mr. Al-Jeddah by UK forces in Iraq breached Article 5 of the ECHR in circumstances where the UK argued the internment was required by a particular Security Council resolution, Resolution 1546. And in the course of resolving that issue, the court set out the approach to be taken in construing this resolution. And the first passage is paragraph 76. That's 3658, MS 3658.
Yep.
The court says this, its role, meaning the European Court's role, is not to define authoritatively the meaning of provisions of the UN Charter and other international instruments. Rather, the question is whether there is a plausible basis in such instruments for the matter before the court. It then reaffirms the general principle that the ECHR itself cannot be interpreted in a vacuum and must account relevant rules of international law. And still at the end of 76, it says, a Security Council resolution should be interpreted in the light not only of the language used, but of the context in which it was adopted. And then the next passage is para 102, which is at MS 3668. So it starts by referring back to paragraph 76. It says the court has reference to the considerations in 76. And then it says this, the court must have regard to the purposes for which the UN was created. In that regard, it cites achieving international cooperation in promoting and encouraging respect for human rights and fundamental freedoms. Then it refers to the Article 24 of the Charter requiring the Security Council to act in accordance with the principles of and purposes of the UN. And it's for those reasons that the court then says, against this background, the court considers that interpreting its resolutions, there must be a presumption that the Security Council does not intend to impose any obligation on member states to breach fundamental principles of human rights. And thus, in the event of any ambiguity, the approach which is most in harmony with the requirements of convention must be adopted. So it's all based on the particular role of the UN, the particular provisions of the Charter about promoting human rights. It was not concerned with construing a treaty about immunity. And precisely the same point arises in relation to the other two authorities. I won't go to them. I'll just give the court the references, if I may. The second case relied on is the NADA case, NADA v. Switzerland, which is at M9 stroke tab 101. In that case, the question was whether a prohibition by Switzerland on Mr. Nada from transiting through Switzerland breached Article 8 in circumstances where Switzerland said it was merely implementing a transit ban contained in a Security Council resolution. And again, the court set out its approach to interpreting this resolution at paragraphs 169 through to 172. That's at MS 3763 to 3764. And it referred expressly back to Al Jeddah. It said, what you have to do is look at the precise context, i.e. the UN Charter, the role of the UN in promoting human rights. And in that context, you have a presumption, not a general presumption, but a particular presumption about interpreting Security Council resolutions. And exactly the same point about Al-Dulami, which is the most recent of these judgments. In that case, the question was whether the confiscation of Mr. Al-Dulami's assets breached Article 6 of the ECHR in circumstances where it was said that the confiscation or the asset freeze was sanctioned by a Security Council resolution. The court set out the correct approach to construing the resolution at paragraphs 139 to 140 of its judgment. That's MS 4115 to 4116. And it adopted exactly the same analysis as I showed the court, as was adopted in Al Jeddah. There was no general presumption about international treaties or measures. It made a very specific point about Security Council resolutions, the interpretation of those resolutions arising from the context, the UN Charter. I now move to the sixth of my heads. This is Article 4. So it's the sixth of my heads and the third of the interpretive approaches. And the key point in considering Article 4, as noted by the Court of Appeal, para 52 of the Court of Appeal judgment, is that in the case of Rantsev, which is the major Article 4 case that the appellant cites, the European Court of Human Rights said that it is the ECHR itself which should be interpreted in harmony with other rules of international law of which it forms part. And that is Rantsev paragraph 274. Authorities tab 13, MS 1497. I also draw the court's attention to the preceding paragraph, Rantsev 273, where the European Court said this: as an international treaty, the convention, i.e. the European Convention, must be interpreted in the light of the rules of interpretation set out in the Vienna Convention of May 23rd, 1969 on the law of treaties. So even the European Court acknowledges that the approach must be one based on international law. And we say as a matter of international law, there is no basis for using Article 4 to prise open Article 31(1)(c) of the VCDR or to read down the UK's obligations to Saudi Arabia under that treaty. The reasons are as follows. Again, Saudi Arabia is not a party either to Article 4 or to the Anti-Trafficking Convention. There's no superior
You made
rule.
this point, obviously, and it's a fair point. Saudi Arabia not a member of hasn't signed up to the Anti-Trafficking Convention. Of course not. Council of Europe. Equally, we haven't signed up to the Arab Charter. We can't. But I was looking overnight at the Arab Charter, and it's a wonderfully firm prohibition on modern slavery. So I know the Anti-Trafficking Convention is more detailed, but where you've got two treaties, two states have signed up in each case, which really say the same thing, I wonder how much mileage there is in saying, well, A isn't a party to B, nor B, a party to A?
2 points there, my lord. First, the approach, as Sir Daniel outlined yesterday, to construction of an international treaty has to be the one that is mandated by the VCLT. The Vienna Convention on the Law of Treaties allows account to be taken of the international law that is applicable between the parties. So the ATC is not applicable to Saudi Arabia, the Arab Charter is not applicable to the UK. That's a formal point, but it's also a correct point because one has to deal with the international approach. But the other substantive point is this. There's a really, really important point of principle here. There is a reason why, certainly in the written case, the appellant was so keen to try and bring Article 15.3 of the Anti-Trafficking Convention into play. The written case wasn't based on some general prohibition on trafficking. It was very specific. It's Article 15.3. It's all over the written case. And the reason was this. It's because Article 15.3 says in terms, right to compensation for victims from perpetrators, for victims of trafficking from perpetrators. And so that allowed the appellant, if it could find a way of forcing that and opposing that to Saudi Arabia, saying, well, it's a straightforward matter of interpretation, not that dissimilar to simple contractual interpretation. You have two provisions, and you have these very clear words, right of victims to compensation. We, as I've said, we don't accept they're clear. The problem with simply saying, aha, but there's this general prohibition, is this. It goes back to the case law that we summarize in paragraphs 23 to 24 of our written case. In Jones and Saudi Arabia, by way of example, the court was faced with the question whether, in a civil claim for torture, there was against a state, against the state of Saudi Arabia, whether Saudi Arabia could assert state immunity. And the court said it is not enough simply for that purpose to overcome the immunity, to identify some general prohibition on torture, even a prohibition on torture which both the UK and Saudi Arabia sign up to. The court has to be able to identify a rule of customary international law which amounts to a superior rule and which is an exception to the immunity in question. And what is more, and this is also crucial, it is not enough in that regard for the court to apply normal common law methods of reasoning. It's not enough to say, well, analogically, it would make sense to have such an exception. The exception would be a good idea. The exception would be consistent with public policy. When one is dealing with international law, one has to deal with international law methods of reasoning. And so one has to ascertain a rule of international law by looking at state practice. There would have to be overwhelming state practice, and there would have to be opinio juris. And can I
understand that, which is, if you're right on that, then I don't know why we've been going into all these other matters. If you're wrong on that, and it doesn't help you, then you're in difficulties, aren't you? I mean, basically, it's Jones and Saudi Arabia. I'm not saying that's the authority in one sense, or the House of Lords decision, but it's what is said in that case, really.
Yes.
What's said in relation to Jones and Saudi Arabia is that we're not looking for a hierarchy of principles here. We've got a construction problem. So we're looking all the way around so many areas to see what can legitimately help us in construing Article 31(1)(c).
Exactly.
So in a sense, it's a lower and more minor exercise than the one that you impute to us.
Mm. I mean, that's in the end, it's what's meant by commercial. And we seem to be going into a lot of issues that don't really seem to cast much light on that.
Well, can I just turn to...
I mean, if it does fall within 31(1)(c), you're dead, and if it doesn't, you win. Isn't that
Yes,
right?
well-
That's the issue in the case.
Yes. But on that,
And nobody says it's professional, therefore it really hinges on the meaning of commercial, exercise of commercial activity.
well, it plainly does, and official functions. But there is an important conceptual point here. It's important to understand why the court in Jones and Saudi Arabia and in jurisdictional immunities reached the conclusion it did. And I'm just reading from paragraph 23 of our written case,
Page 196, 197,
Yes.
yep.
where we summarise Jones and Saudi Arabia. And if we can just look at what Lord Hoffman said, quoted at the top of 197. State immunity is a procedural rule going to the jurisdiction of a national court. It does not go to substantive law. It does not contradict a prohibition contained in a jus cogens norm, but merely diverts any breach of it to a different method of settlement. And in that regard, he's quoting the book Fox and Webb on state immunity. So arguably then, there is no substantive content in the procedural plea of state immunity upon which a jus cogens mandate can bite. So going back to the point that this is all an exercise of construction, yes, it is an exercise in construction, but it's an exercise in construing a term of the treaty that's about immunity, that's about this procedural bar. So we say it will be conceptually flawed to try and bring into play a substantive prohibition in order to interpret that that provision. As Lord Hoffman goes on to say there is no substantive content on which the procedural plea can bite.
I understand your point about this, really. The fact that human trafficking is a revolting thing and is the subject of lots of international agreements doesn't really bear on the issue of whether particular employment of somebody as a member of your domestic staff is a commercial activity. Yes?
Yes.
Okay.
And also, just on that point, I also note that in Kalyan's submissions, this is paragraphs 95 to 96, CV1, MS273, Kalyan actually characterises Article 4 as giving rise to substantive obligation. Now, at this point, I'm addressing Article 4. So if that's right, applying Lord Hoffman's reasoning, and it's similar to the reasoning of the ICJ and jurisdictional immunities, it is just wrong as a matter of concept to try to apply Article 4, even if it did somehow bind Saudi Arabia, to read down the immunity provisions of Article 31. Just briefly, the appellant says that Article 4 gives rise to particular positive obligations. They talk about Article 4 requiring an appropriate legislative and administrative framework. Well, that submission fails for all the reasons I've given. Article 4 doesn't even come into play, but even if it does, the question of what is an appropriate framework is a question for Parliament. It's not a question for this court. And they also talk about a particular obligation to investigate situations of potential trafficking. And again, that fails for all the reasons I've given. Article 4 just does not come into play. The seventh of my heads is Article 6. And responding to the appellant's case, which is that Article 6 would be breached if the immunity in this case is upheld, there is an initial question of engagement, whether Article 6 is engaged. We deal with that at our written case, paragraph 109. We say the better view is that Article 6 is not engaged in this case. We also refer to the submissions of the FCO on this point, paragraphs 43 to 59 of those submissions, and 66 to 79. And we say that the point has been determined already by the court in Holland and Lamp and Wolf. I acknowledge that this issue is going to be reventilated in Benkabush. I don't want to spend more time on it now. We say it's not necessary to determine that issue for this purpose, because even if Article 6 is engaged, on the question of proportionality, the decisive question is whether a state is acting in compliance with generally accepted or generally recognised rules of public international law. And we address all of this in detail in our written case, paragraphs 110 to 111. The proposition that in relation to immunity, compliance with international law obligations is decisive follows from a long line of ECHR cases which we set out in those paragraphs. The most recent is the Jones v UK case, where at paragraph 189, the court said in terms, having quoted some of this earlier case law, the decisive question is whether the immunity applied reflects generally recognised rules of public international law. The appellant tries to get around that by saying, well, the international rule here, i.e. Article 31 of the VCDR, is ambiguous, and before you bring that rule into play under the Article 6 proportionality test, you first effectively apply the ECHR to the international rule and only then bring it into play. So it's a way of rigging the game before you're on the field. Well, we say there is simply no basis for that approach in the jurisprudence of the ECHR, and the approach is circular. What they're effectively saying is before you apply Article 6 to determine whether there is proportionality, you first of all apply Article 6 to the relevant international law obligation. Moreover, as recognised in the ECHR case law, there is a margin of appreciation afforded to states. So when one is applying this proportionality test, the question is not, the precise question is not what is the relevant international rule of international law. It is, does the state, in asserting reliance on the immunity, fall outside currently accepted international standards? And that point is particularly supported not just by Jones, but by an earlier case, Fogarty, that's M8 tab 89, where, and the references are para 33, MS 3415, and then paragraphs 36 to 37. And in Fogarty, the court made this point, that this was somebody suing the US for an employment claim, and the US asserting state immunity, and the question was whether that plea of state immunity breached Article 6. The court said, although international practice is divided on whether state immunity can arise, the UK was not alone and did not fall outside currently accepted international standards. And finally, on Article 6, I reiterate, it's not necessary to conduct a substantive proportionality assessment. In other words, the proportionality assessment stands or falls on the question of international obligations. You don't go beyond that and start asking general questions about diplomatic functions and whether those are part and parcel of the object of the rule in question.
Earlier in the paragraph to which you refer,
yes,
the European Court observes that there appears to be a trend in international and comparative law towards limiting state immunity in respect of employment-related disputes. What are they talking about, Mr. Sarouk?
Well, that is in relation, as I understand it, to state immunity, which is not an issue in this case, but is an issue in the Benkabush case.
But in terms of state immunity, what are they talking about? Where do we see the trend?
Well, Lord, I don't want to mislead the court because I've not prepared on the basis that this is a state immunity case. All I will say is that the positions in relation to state immunity and diplomatic immunity are different, and the scope of state immunity in relation to employment claims is the subject of the Benkabush appeal, which the Supreme Court will be hearing next month.
I mean, the trend in question, surely, is the tendency of courts in different countries to treat the employment of relatively low-grade employees as not being exercises of sovereign authority, which is the test for state immunity, although, as you say, not for diplomatic immunity. So that, for instance, if one's talking about a telephonist in the Lithuanian embassy, that's one thing. If you're talking about the employment of an ambassador, it's a completely different thing. I think that is the trend, isn't it?
Well, that may well be, but the point I seek to draw from Faulty is simply where all that can be said is there is a trend and practice is divided. It's enough if the UK can say that it's within the bounds of what is generally accepted as practice. That the fact that there may be a division of international practice on the issue is not fatal to reliance on this line of case law. That's the point I'm trying to derive from this.
Thank you.
Finally, my eighth and very, very brief head of submission, just very briefly, the Callian submission. Just one observation. I note that Mr. Otti made very little, if any, express reference to those submissions. I simply observe that at the end of the Callian submission, this is paragraph 98, there is a claim for a declaration of incompatibility. So they're not just saying this is a question of interpretation, they are saying declaration of incompatibility. And I simply observe that there is no claim by the appellant for such a declaration. Indeed, Mr. Otti, I think, expressly disavowed the notion that this is a declaration of incompatibility case. And also Callian has no permission to bring such a claim now before the court. It wasn't in their application to intervene, and it wasn't in the order the court gave, and we've put before the court the Callian application to intervene. Finally, and in conclusion, we say that assuming we are right on the basic situation as to a basic ordinary employment claim, the attempt to bring trafficking into play, to rely on human rights, does not change the position. The points we make are not technical points. We're talking about an international obligation owed by the UK to Saudi Arabia. If the appellant's approach is adopted, the UK would be placed in breach of those obligations. If the appellant wants to bring in these allegations of trafficking, there has to be some principled basis, and we say there is no principled basis, particularly where the appellant's case is contingent on alleging breach of Article 15.3 of the Anti-Trafficking Convention. And we say, for all the reasons I've given, that to adopt the appellant's approach would in practice make the VCDR unworkable. It would, in practice, extend the scope of the immunity to encompass ordinary employment claims and potentially to encompass ordinary claims for breach of contract. It would be a very dangerous road indeed for this court to travel down. And finally, I remind the court of the question of reciprocity. if the appellant's approach is adopted with the consequences that we say would follow, the effect would be felt profoundly, not just by foreign diplomats in this country, but by UK diplomats abroad. Can I assist the court with any further questions?
Thank you very much indeed, Mr. Swoop. Thank you.
My lords, my lady, before I put my cross-appellant's hat on, perhaps I might take 30 seconds just to assist my Lord Wilson with two of the questions that he put. I think the first one was about the intersection of the Arab Charter and the ATC. Why can't you put them together? And I'd simply...
Yes, why can't you put them together? I mean, it's perfectly clear from the Arab Charter, to which Saudi Arabia has, of course, signed up, that Saudi Arabia takes the same firm and extreme negative view of modern trafficking as we do, which makes, in a sense, this whole inquiry rather curious.
Well, my lord, I accept that there's an element of curiosity about it. I'm going to make two very, very brief points just to assist on this. First of all, as I indicated yesterday, I think the appellant has used the Arab Charter and the Slavery Convention and other conventions to generate momentum. In fact, we haven't had any argument about the interpretation of Article 10 of the Arab Charter. And nor have we had any argument, frankly, about how the Arab international legal community would respond to Mr. Otti's harmonious interpretation argument. So it may be that if we were before the International Court of Justice, there would be these issues to get to, but this is not part of the appeal. And the second point, again, my Lord Wilson, just to address your question about what is the trend in state immunity, and Lord Sumption's response, well, isn't it the trend in the courts? It's not the trend in the courts. It's the trend in the legislation that states are adopting on restrictive immunity, and there is a lot of legislation that states have adopted to deal with restrictive immunity. The UN Convention on Jurisdictional Immunities has not come into force yet, but that is the trend that's being referred to.
Restrictive immunity is now almost universally accepted, isn't it? I mean, China is the principal state which doesn't accept it.
My Lord, it may be so, but following Trentex, the United Kingdom decided to legislate, and it's been the patchwork of legislation that has generated the trend, that has generated the court judgments. But this is not a point that I need to debate. My lords, my lady, I'm now appearing in the cross-appeal, if you like. There are two documents that we handed up and made available to Mr. Otti and others. There is one which is a Canadian document which will be self-evident. It's a very brief document, which is there for completeness because it's referred to in one of the texts. The second document, if I may just draw to your attention, because I hope that it may both assist the court and also Mr. Otti in the time available to him, and that is just entitled Pleadings, Documents and Principal Authorities References. It's again a very brief three-page document that you should have. That's the one with a green tab on the top, and I've attempted here simply to give you, in a systematical, analytical fashion, all the references that emerge both from our case and from the cross-respondents case that deal with the issue of service, and it may just speed things along a little bit.
Thank you.
The pleaded cases are set out at the bottom of that note, And I would simply draw attention to the submissions of the Secretary of State. There were written submissions which are in core volume 1, starting at MS 582 and following. And then there is the Government Legal Department letter dated the 11th of May 2017, which is a loose leaf letter. I will touch upon those in my submissions, but would very much like to urge on the court that you have regard to them. I don't propose to simply replead orally the stated case. The stated cases are there, they join issue. I'd like to try and tease out some of the issues that I hope will be of most interest to the court. The judgment of the Court of Appeal on service is at paragraph 78 to 95, and that's at core volume 2, MS 633 to 637.
Yes.
And just to, you don't have to look at them, I'll give you the references, but just to identify that there are no provisions in the Vienna Convention on diplomatic relations that deal with service explicitly. So we are engaged in a slightly different exercise from the exercise in the appeal. The question on service is, what is the effect of the inviolability provisions in the convention? And there are 3 inviolability provisions that come into play. There is Article 22, which is the inviolability of the mission. There is Article 29, which is the inviolability of the diplomatic agent. And there is Article 30, which is the inviolability of the private residence of the diplomatic agent. And Article 30 is simply a renvoi back to Article 22. The residence has the same inviolability as the mission. The language used in Article 29 relating to the inviolability of the diplomatic agent is slightly different, but the word inviolability remains there, and that's going to be the core of my submissions. Now, I should also emphasize that it is no part of the respondent's case that that service cannot be affected in some shape or form. And I make that point for 2 reasons. First of all, because that was almost the starting question that the Master of the Rolls asked to himself in the Court of Appeal's judgment. It would be absurd if there could be no service in circumstances in which there are exceptions contemplated. But this also goes back to an issue that arose. This issue arose of whether there was an avenue for service in the employment tribunal. But I say right at the outset and very candidly that it is no part of our case that there cannot be service. The question is, how should service be effected? And we take the view that there is, in fact, are VCDR consistent ways of serving. The position that we advance in our written case, and which I will develop, is that the appropriate means of service is via the Foreign Office to the Ministry of Foreign Affairs of the sending state, in this case Saudi Arabia. The Secretary of State takes a slightly nuanced view, and I would very much invite you to read his submissions. He says that service should be via the Foreign Office, but the Foreign Office then will invite the sending state's diplomatic mission in the United Kingdom to come in and collect the document. So there is no intrusion into the inviolability of the mission, because the mission comes to the Foreign Office. And that was the purpose of the Foreign Office's letter, the loose leaf letter. And I should say that while we maintain our primary case that service should be from the Foreign Office to the Ministry of Foreign Affairs in Saudi Arabia, we accept that the Secretary of State's approach is VCDR consistent? But it does give rise to certain practical questions, or a certain practical question, notably in relation to when time begins to run. But we would be content to rest on the Secretary of State's approach if it comes to that. Now, in this case, the Employment Tribunal, within the scope of its rules, Rule 69 of the Employment Tribunal rules as was at the time in the 2004 rules, attempted service by post on the al-Malki's diplomatic residence, on the Saudi embassy in London, and on the solicitors, RPC. There is also in the papers, and you'll see this referred to in the Secretary of State's intervention as well, there was also an attempt at service via the Foreign Office, but it was addressed to the wrong Foreign Office location by the Watford Employment Tribunal. And there was a response from the Foreign Office Consular Division saying this is the wrong location, it should be addressed elsewhere, and that seems not to have been followed up. And the issue of service on the Foreign Office did not feature in the Employment Tribunal, in the Employment Appeal Tribunal, or before the Court of Appeal. So I make the point by way of completeness. And you'll see that it is addressed expressly by the Secretary of State in his submissions at paragraph 22, footnote 11, and that's Core Volume 1, MS 584. And there's no need for me to say anything more about it here. The judgment in the Court of Appeal below, against which we are appealing, and as I say, I don't need to take you to that judgment unless you wish me to do so. But the Court of Appeal held that personal service, and I emphasize personal service that is on the diplomat himself at the mission was prohibited by the inviolability provisions of Article 22 of the Convention. The court also held that personal service on the diplomatic agent was prohibited under Article 29. In other words, he couldn't be accosted in the street and served. The Court of Appeal did not make the third point, but I'm assuming that they would have done had they felt it necessary to do so, because it's entirely consistent with the two observations that I've just made. They presumably would have concluded that personal service at the residence of the diplomat was also prohibited by Article 30. In other words, if a process server went along to the residence of the diplomat and knocked on the door. They didn't say that, they didn't need to. It follows from what they said in the other two parts. But what they did say was that service by post to the residence and service by post to the mission was permissible. And this is at paragraph 94 of the judgment. And this is what we are appealing against. And they reasoned that this did not infringe inviolability, relying largely on a 1973 US first instance case called Renshard against Humphreys, which is at, and I'm again not proposing to take you to this, but it's at Authorities 11, tab 120, MS 4577. You'll see it on the references sheet. And this was a case in which service was attempted on the Brazilian embassy in the United States in a case which was intended to implead Brazil. And I mentioned that this was 1973 because the US Foreign Sovereign Immunities Act in 1976 took a different view, which is why we say in our pleaded case that Renshard against Humphreys is bad law even in the United States. This was a matter that was explicitly addressed in the Foreign Sovereign Immunities Act. And you'll see this discussion of Renshard against Humphreys being bad law in the Denzer citations, which I will take you to, but which are set out in my reference sheet. But the Court of Appeal below relied on Renshard against Humphreys. So in the first place, there is questionable solidity for their analysis. The Court of Appeal also, in its judgment, failed to address service through diplomatic channels, although this was explicitly before the court. Indeed, there were some exchanges that I had with questions from the court. Lord Justice David Lloyd-Jones, in particular, raised these issues in a rather truncated hearing. So the issues were definitely before the Court of Appeal. And there is a reference at paragraph 92 of the Master of the Rolls' judgment to service through diplomatic channels, but it's simply dismissed on the grounds that this would be unreliable, although there is no reasoning at all as to why it would be unreliable. And in particular, the assertion of unreliability, we would say, is pretty questionable in circumstances in which that is the mandated method of service in the case of state immunity
I wonder
cases.
whether you're being entirely fair to Lord Dyson when you say there's no reasoning. The sentence is, the difficulty with this lies in its unreliability, the receiving state may refuse to effect service by these means.
My Lord, I certainly don't want to be unfair to the Master of the Rolls on that. This is quite a big issue. It's addressed in half a sentence, and in circumstances in which Section 12 of the State Immunity Act and the CPR rules, in fact, address this as a matter of the common approach.
And that's also a feature. I mean, Section 12. There's a very similar provision to Section 12 in the US statute, and I think I'm right in saying that is a practice which is normally mandated by statute in very many countries.
Yes, indeed.
So there seems to be a practice regarding state immunity and from service, but no corresponding practice in relation to individual diplomats.
We accept that entirely. My point is simply that, in fact, there was some submissions on this to the Court of Appeal, but in fact it was addressed in this half a sentence. The judgment of the Court of Appeal does acknowledge at paragraph 91 that the position on service by post is, quote, not as clear as one would wish, and we are before you in the hope of getting clarity, if I can put it in those terms.
Can I just ask you to tell us what exactly is it about the process of service by post which violates the residence of the diplomat? Is it the fact that a document comes physically through his letterbox and therefore enters his private space, so to speak?
My Lord Sumption, you are anticipating exactly what I'm going to be coming on to and developing, and I would like to, as well, there take you to the submissions of the Secretary of State, because one thing that the Secretary of State does in his submissions is set out precisely the concerns that they have about this.
Well, their concerns are about the difficulty of the Foreign Office and foreign officers being able to monitor what's going on as regards their diplomats.
My Lord, with respect, I think it goes beyond that. It's not only the question of monitoring. They also identify a whole series of issues that they consider would follow, which would create difficulties, and I'm about to come on to those. But what I'm going to do, if I may, as I get there, is to adopt the same kind of methodology as I did with you yesterday and take a sort of naked interpretation approach to the Vienna Convention and test it, and then see how all of these things fit together. And as I've said, there are three inviolability provisions, Article 22, subparagraph 1 and 2, Article 29 and Article 30. And we have to approach the interpretation of the word inviolability, again through the prism of the Vienna Convention on the Law of Treaties and the general rule. So the starting point is, what is the ordinary meaning of inviolability in its context and in the light of the treaty's object and purpose? And the term is not expressly defined, but our submissions are that the meaning of the word inviolability is clear. And to anticipate what I will come on to, I hope, be able to prove in just a moment, our contention is that inviolability of person and premises means that the person and the premises are not to be infringed by any act of the executive and adjudicatory branches of government in a manner that would impair the efficient performance of diplomatic functions. And to try and make good on that should not be infringed by any act of the executive and adjudicatory branches of government in a manner.
I mean, do you need the coda in a manner that would interfere with diplomatic functions? I mean, if a policeman violates a diplomatic residence by coming in without permission when the diplomat is away, one would think that that was a breach of the inviolability, notwithstanding that it had absolutely no impact on the performance of his diplomatic functions.
Yes, that would be. Now, to try and make good on this, first of all, I've referenced executive and adjudicatory branches of government, but not the legislative branch of government. And Article 41, paragraph 1 of the VCDR requires or imposes a duty to respect the laws and regulations of the receiving state. So it's quite clear that the diplomat is not, as it were, is not relieved of the obligation to respect the laws of the receiving state. But the relief from infringement of executive and adjudicatory actions follows from the context of the convention as a whole, we would say. So it follows from the immunities provisions in Article 31, subparagraph 1. It follows from the provisions in 31, subparagraph 2, that the diplomat is not obliged to give evidence. It follows from the provisions in 31.3 that the diplomat shall have no measures of execution directed against him, except in the case of the 31.1 exceptions. And it follows from the exemptions in Articles 33 to 36. So we think it's quite clear that inviolability is focused on the acts of the executive and the acts of the courts.
But say the exemptions in Articles 33 to 36.
Yes.
Could we look, if it's convenient to you, briefly at Article 34?
Yes.
We've got at 997.
Yes. And there is 34.
Diplomatic agents shall be exempt from all dues and taxes, personal or real, except.
Yes.
And then there are 6 taxes, sorts of taxes that may be leviable against a diplomat here. Now, how do Revenue and Customs levy a leviable tax on a diplomat?
Well, my lord, first of all, the subparagraph D is the dues and taxes which are on private income and which bears this relationship to 31.1c and Article 42 as well. A number of these are either indirect dues and taxes, and therefore are such as, for example, value-added tax.
I'm not sure we need to get into the detail of what the taxes are.
Yes.
My query was simply, there are circumstances in which HM Revenue and Customs are entitled to levy tax against diplomats. And I was going to ask you how they go about indicating to the diplomat that something is owing, and whether that would be by post to the residence.
My lord, I think that the answer is that I don't know, well, rather, I should say, I don't know how they go about drawing that to the attention of the diplomat in circumstances in which they need to collect something, because I think that the answer is that it is collected automatically through the transaction. So, for example, in this country, value-added tax is charged simply in the transaction over the counter. So there is no levying of, there is no collection of the tax from the.
Suppose that the Inland Revenue wishes to make an assessment on a diplomat for income tax on his personal investments in commercial undertakings in the United Kingdom. Is it a violation of his residence to post the assessment to him with the usual notice requiring payment within X days?
My lord, we would say that it is. Unfortunately, this is not a question that I can answer. If anything turns on it, I would invite your lordships or the court to raise the question with the interveners, and I'm sure that they would be able to give an answer in writing. But we would say that any attempt to raise that those taxes would touch upon the issue of inviolability. Now, it may very well.
How far
be,
does this go, if I may ask you this? Is the putting through a diplomat's letterbox of any unwelcome document a violation of his residence?
If the postman or woman from the Royal Mail or someone from FedEx comes and knocks on the door and says, Mr. Diplomatic Agent, I've got some mail for you, we consider that that does not engage the executive or the adjudicatory functions of the state, which is why I formulated this as an exercise of the jurisdiction, the executive and adjudicatory functions of the state.
So if a planning notice, for example, is put through a letterbox, is that a violation of the residence?
Well, if it would impair the efficient performance of the diplomatic functions, then I expect that a case could be made. So if the local authority put in a notice through the letterbox which said, we're about to cut off your water, or we're about to cut off your electricity, then I imagine that that would indeed be regarded as a breach of the inviolability provision.
Right. So we are having roadworks performed outside your premises. You will be without electricity for 12 hours. That's a violation, is it?
My Lord, I think that you're inviting me to go down a never-ending road of...
Well, indeed I am. I'm wondering where it does end.
Yeah, well, that's not the case that I'm making with respect.
I think you would say that where it is purely administrative, like cutting off the water to enable pipes to be laid outside or repaired, that's a different matter. But when it's some sort of aggressive or punitive action or anything approaching that, that would be caught.
I would indeed, my Lord. Thank you. Thank you for that. And I'm going to try and again make good the practicalities of this by reference to what the Secretary of State has said, because the Secretary of State identifies a number of very specific concerns. Now, the language of Article 22, subparagraph 2, and the language of Article 29 also adds something further to inviolability, because it also talks about the dignity of the mission and the residence, and anything that would amount to an attack on the dignity of the diplomatic agent. Now, we don't here need to stand and fall on any issue of dignity, because I think the point is the more general point, that it relates to the executive and adjudicatory assertions of jurisdiction. And taking my Lord Newberger's statement, which we would adopt, it's not the passing administrative actions. Now, our contention is that service by post comes within this interpretation of inviolability, because it is by any means an assertion of the executive, or perhaps might be of the adjudicatory jurisdiction of the receiving state. And we would say that postal service breaches the inviolability of the mission or the residence, wherever it is delivered, and of the diplomatic agent. And coming to the issue of how this would impair the efficient performance of diplomatic functions, I would like, if I may, because otherwise I fear it may be lost at the back of a big bundle, take you to the Secretary of State's intervention, which is in core volume 1 at MS 583. And I'd like to take you, first of all, to paragraph 21 of that. The discussion of service by the Secretary of State starts at paragraph 15, which is on MS 582. But I'd like to take you to paragraph 21. And in paragraph 21, the Secretary of State says, in the Secretary of State's submission, the principle of inviolability is not confined to physical incursions against the person or property of the embassy and or the diplomat. And my Lord Sumption, I think this comes to exactly the point that you were putting to me. They go on to say, service of legal proceedings, and I think the legal proceedings is important, by post, has immediate consequences in drawing the diplomat into the receiving state's legal process. And that's the start of their concern. That's the chapeau of their concern.
So the same principle would apply to any form of substituted service, even if it was non-intrusive, for example, service by advertisement.
Yes, yes.
It's got to be done through the embassy, that's your point.
Well, our point is that it has to be done through the Foreign Office.
Through the Foreign Office.
Through the Foreign Office.
And how do you know that?
Well,
Can one...
Just told you.
well,
You've just told us that, but now how would I have known that without that? Here I want to serve somebody, and I've got to be served today within the rules. How do I know what to do? Secret or what?
my Lord, this is a very important question, if I may say so, and a very difficult one, because under the Employment Tribunal Constitution and Rules of Procedure regulations, you wouldn't know that. Because there is nothing in the Employment Tribunal rules that actually says to the Employment Tribunal, this is what you should do. Now, we do have in the evidence here, and this is at the claimant's letter, which is at Core Volume 1, MS 77, we know quite clearly that the claimants were aware that those that they were seeking to serve were diplomats, and they sought to persuade the Employment Tribunal to serve on the Saudi embassy, to serve on the residence, and to serve on the Foreign Office. So they were attempting to cover all of their bases. But there is a fundamental problem that it's actually not addressed in the Employment Tribunal rules. And if you are with me on the issue of service, the Employment Tribunal rules are going to have to be changed to bring them into line, perhaps with some of the CPR provisions relating to service as regards the state.
I think the point is more, where do we get this from? And you say we get it from the articles that's been set out in the Secretary of State's case in paragraph 18. Is that right?
We get it from there in international law, and the question is...
And then we get it from Denza.
We get it from Denza, but we get the service through the Foreign Office by, we would say, asking the question, what would be a VCDR consistent method of service?
Before we go there, going back to Denza briefly, we've got the quote at paragraph 21 of the Secretary of State's submissions.
Yes.
Have you got that to hand,
Yes.
Sir Daniel?
Yes.
Although service of process does not involve arrest or detention, was Denza there talking about personal service, Sir Daniel? Because I think she was.
Well, it looks as if she is from the extract here.
I mean, will you take it from me that 1782 indicates she was talking about personal service? And if I'm wrong on that, after the short adjournment, show me that I am wrong.
Well, I'm happy to accept that you're correct.
Then this quote is misplaced.
I think this quote is misplaced.
Very well.
And there are 3.5 pages of Denza which, in fact, address the issue rather more fully, which I'll come to. And, my Lord, I should say you were inviting me to make further submissions after the short adjournment. I think my time's up when we get to the adjournment, so which is one of the reasons why I'm speaking with some rapidity. But I would like to also then go on and take you to paragraph 24 of the Secretary of State's submissions, where the Secretary of State begins to identify with a little bit more granularity what the impairment of functions might mean. That's true. At paragraph 24, he says, affecting service via the FCO also reduces the risk of court officials inadvertently serving process on individuals with diplomatic immunity, an act which may lead to strong and justified protests. And if I may then take you to paragraph 29, and I'm not inviting you, as it were, to come back to me on each of these individual items. I just want to draw to your attention what the Secretary of State is saying. At paragraph 29, if service were effected by post to diplomat's private residence, the picture would be very different from the approach that the Secretary of State proposes. A head of mission might be unaware of problematic behaviour or conduct on the part of their staff. Their staff may indeed then seek to hide it. They go on to say, the Secretary of State at paragraph 30, service by post could equally well have the result that staff and their families were rendered more vulnerable. There is, for instance, no guarantee that postal service would be reliable. If documents were lost in the post, processes could run without the question of immunity ever having been considered.
That's a general point about postal service, isn't it?
Well, it is a general point about postal service, and in circumstances in which we may be inclined in this jurisdiction to rely on the efficiency of the Royal Mail, the Secretary of State goes on to say in paragraph 31 that the United Kingdom has representatives in other states where there is a very real risk of legal processes being used inappropriately in order to harass diplomats and their families, and where service by mail may be not entirely reliable. And the interpretation on service that is going to come from this court is going to be picked up in the reciprocal nature of the VCDR and may be relied upon to purport to effect service against British diplomats in very far-flung parts of the world. And that's precisely the concern that the Secretary of State is expressing. There is...
What about electronic service?
Well, I think electronic service would raise the same question. There are concerns about the reliability of electronic service as well. And one of the features that we have when it comes to service through the Foreign Office, whether it's service through the Foreign Office as the Foreign Office would contend, or service from the Foreign Office through the Ministry of Foreign Affairs, is that it is then for the Foreign Office to certify the date on which service is affected. They have a record, and time begins to run from that point. And in circumstances in which otherwise proceedings may simply take their own course, including default judgments against a diplomat, the issue of time beginning to run, in circumstances in which the diplomat himself or herself cannot lawfully waive immunity themselves, he or she would have to go back to his head of mission, who no doubt would have to refer back to the Ministry of Foreign Affairs. The flexibility of the Employment Tribunal rules of procedure, which Mr. Luckhurst, before the Employment Tribunal, prayed in aid as the advantage of the employment proceedings, is in fact a very, very considerable challenge for states, because states work in a bureaucratic, formalistic, and slow fashion. Now, that's not to say that one should not try and chivvy states along, but it is to say that one should be aware of the practicalities and the realities of the world in which they live. And that's what the Secretary of State is saying. Now, the Secretary of State is not saying anything that is unusual, because if you have a look at and in the interest of time, I'm not going to take you to it, but this is one of the principal cases that we would rely upon. If you look at the case of Hellenic Lines against Moore, which was a 1965 district court decision in the United States, in the district court of the District of Columbia, which concerned an application of mandamus to compel service on the Tunisian ambassador.
Where do we find that?
I'm sorry?
Where is that?
That is at, apologies, that's at Authorities Bundle 11, tab 119, and that's at MS 4569. And just to give you the reference, at MS 4574, there is a very long footnote number 5, where the judgment recounts the US Foreign Secretary's concerns, which overlap to a considerable degree with the concerns expressed by the Secretary of State in these proceedings.
Is there an argument that it's all very well looking at these articles, but if in relation to a claim which relates an action that relates to his commercial activity, we should be looking at Article 31. He doesn't enjoy immunity from the civil jurisdiction. Why wouldn't that include service?
Well, my lord, I think that the position being taken by the Foreign Office, and it's certainly the position that we are taking, is that if there is an allegation that the claim comes within the scope of one of the exceptions to Article 31(1), service should be effected in the normal way through the Foreign Office to enable a decision to be taken about whether immunity should be asserted or immunity should be waived.
Yes,
if immunity is asserted, then we would be into the kind of exercise that we're contemplating now to test whether immunity is warranted.
Yes, I see. Thank you.
Now, so we contend that the Court of Appeal failed to consider these issues or to undertake a general rule analysis. Now, having come to this conclusion, I must say, because certainly Mr. Ottey is going to take the point against me this afternoon, that when we then go to the travaux préparatoires in order to confirm what I say is the clear meaning derived from an interpretation of the treaty, that the travaux préparatoires muddies the waters a little bit. One of the reasons why I put down on this reference sheet all the travaux préparatoires chronologically is because I feared I might not have the time to take you through them systematically.
Thank you.
And did not want to be accused of any inadvertence in overlooking a point that was of assistance to my learned friend.
Very fair.
Thank you. But what I would say, galloping through those travaux, just to give you a sense of them, in 1957, there was some reference to the issue of service by post. And this is in the International Law Commission's report, 1957. That's at the first supplementary volume, tab 170 at page 22. And the text there says in very explicit terms, I'm paraphrasing, but it's that there shall be no service by post. And this is reflected in the subsequent discussion. We then get to 1958, and the winds begin to shift in Mr. Ottey's direction, because there is some discussion, and I would, of course, invite you to have a look at that as well. There is some discussion in the 1958 Volume 1 yearbook, which is at A3, Authorities 3, tab 26, MS 1720 to 1721. So there are 2 pages of rather dense discussion about why the proposed rule that there should be no service by post is correct. And this is where I took a point against myself yesterday, because Sir Gerald Fitzmaurice, the then legal advisor of the Foreign Office, was the one who was in fact saying there should be service by post. So the United Kingdom member seemed to be moving in a different direction. But we then come to the Vienna Conference, and this is the document at Authorities 3, tab 28, MS 1735.
Yes.
And we see a reference to an amendment by the Japanese representative at the Vienna Conference, which concludes that he would withdraw his amendment, which goes to the issue of service, on the understanding that it was the unanimous interpretation of the committee that no writ could be served even by post within the premises of the mission, and that amendment was then withdrawn. So when one comes to the travaux, we have bookends at the beginning and at the end of the discussions, which say no service, but then in the middle there is this rather detailed discussion which seems to contemplate the possibility of service. So against me, it's going to be said that the travaux muddy the water, and I must in all candor accept that. But my response in anticipation to Mr. Ottey is that the travaux can't open up the general rule interpretation.
Did you say that Mr. Takahashi's statement of the understanding was confirmed to be correct. No, he said it. I can see what he said, but I not having looked at this very carefully until the talk. Nobody seems to have said, yes, we agree, that is our understanding.
I'm not sure which Japanese delegate you're referring to.
Yes, Takahashi, who said this.
But my lord, I think that you're looking at the 1958 discussion rather than the official records discussion, because there was a change in Japanese delegates.
I see.
And the Japanese delegate in 1961 took a rather different view from the Japanese delegate to the one that you're looking at.
What view did they take in 1961?
Well, if I can take you to that, then that's
I see.
Authorities 3, tab 28.
Well, that's what I'm looking at.
That's what we're looking at. Yeah.
My lord, if it's helpful, it was actually Mr. Takahashi in 1961. If your lordship...
I know, but I'm looking at tab 28, page 1735.
I'm
where
sorry.
he does refer to his unanimous interpretation. What I'm asking is whether, he says it, but was it confirmed as being the unanimous interpretation? That's all I'm asking.
My lord...
Or are we to assume that it was by virtue of silence?
My lord, apologies for that. I think that
worry.
we have to assume that because the amendment was withdrawn and not voted on.
Fine, thank you very much.
Unanimous interpretation of what?
Of the plenary committee that was dealing with the...
Yeah, but I mean, is this said to be the unanimous interpretation of the violation provisions which actually were in the convention, or is it said to be the unanimous view of the position that would exist even without the convention?
I think it's simply a unanimous interpretation that no writ could be served, even by post.
Okay, thank you.
Now, there is very, very limited case law on this, and such case law as there is mostly on personal service. But in Hellenic Lines against Moore, the action for mandamus to compel service on the Tunisian ambassador in proceedings against the state, in fact, there was some discussion of service by post.
Yes.
And just in the interests of the very brief time that I have, I'm going to simply give you the reference. It's at volume 11.
4569, tab
4569,
yep.
precisely. And it's in the bottom right-hand corner. There's a reference to service by post.
Bottom right-hand corner of what?
Of that page that you just referred to, my lord. So it's
Yep, thank you.
You'll see, this is quoting the State Department, although service of process on an ambassador by registered
4572.
mail might avoid some of the problems, it would raise others.
Yeah.
And we say that Hellenic Lines against Moore of 1965 was endorsed by the U.S. Second Court of Appeal, Second Circuit's Court of Appeal, in the case of Takiona against the United States,
Right.
which is at sub 3, tab 175. And there are a number of paragraph references there, paragraph 78, paragraph 86, and most importantly, paragraph 88. And the reason for drawing Takiona to your attention is that obviously between Hellenic Lines and Takiona, we had the Renchard and Humphreys, and Takiona is the appellate, the superior appellate jurisdiction, and more recent. Now, the comment...
Was that final case dealing with service by post, Takiona?
No, it wasn't. It was dealing with personal service
fine,
on
thank
Robert
you.
Mugabe.
Thank you.
But what they have is a discussion of Hellenic Lines.
They do approve of Hellenic, yes, it's quite true. Yep.
Now, the commentators largely took the view that service by post was prohibited, or in the fullest discussion of this by Denzer in diplomatic law, that there was a consensus that was emerging in favor of the prohibition on service by post. And the Global Affairs Canada consular note that I also handed up to you is part of Denza's discussion of the trend. And if I may, I'll simply...
Was there an emerging agreement about what did count?
Well, the emerging...
Or I was saying can't post.
I think the emerging agreement appears to be service through the Foreign Ministry.
That's when it is served by the foreigner's foreign ministry or our foreign ministry.
No, so a claimant in this country or a claimant in another country would serve through their foreign ministry for transmittal.
Service would then be when it was arrives in the foreign...
Then the Foreign Office would then certify on the date that the document was handed over, and time would begin to run from that point.
And what about subsequent documents? You serve the proceedings in accordance, they are then validly served.
Yes.
Does every subsequent document have to be served in that way?
My Lord, I would not want to inadvertently mislead you, and the answer is that I don't know. On
Presumably, by the time the subsequent documents come to be served, either the diplomat will have defaulted or he will have appointed solicitors to represent him, and the service would be affected on them.
I think that is correct. And
obviously, if you appoint solicitors, but if he doesn't,
I think the range of possibilities are.
Okay, well, don't worry. You haven't got much time. Don't worry. Thank you.
And I would simply invite you to have a look at these, and in particular at the Denza, and the references there are MS 1778 to.
Yeah, we can see what they are. You very helpfully set them out. That's kind. And you'd like us to look at all of these?
They're very brief. Most of them.
No, that's fine. I'm not complaining.
I would encourage you to do so, which is why I've set it out. Well, then let me come to a conclusion.
Of course.
Our primary position is that service should be via the Foreign Office to the Ministry of Foreign Affairs in Saudi Arabia in this case. We say that is consistent with the state ownership of the immunity, because when you draw that to the attention of the Ministry of Foreign Affairs, they are the ones who can waive immunity or decide not to. We say that is consistent with the practicalities of proceedings, such as time beginning to run and risks of default proceedings. And we say that it is consistent with the risks of the unreliability of the post. But our alternative position is that we would accept that the Secretary of State's approach, which is that the Foreign Office here would then call in the embassy located in London to get them to pick up the documents, and that would amount to service. We accept that would be VCDR consistent. And there would also then be a Foreign Office record of time beginning to run, and the Foreign Office would be engaged in the way that the Secretary of State has said that's important. And, my Lords, I think that's probably my time up. I heard the clock tick.
Thank you very much, Sir Daniel.
And I should just say that brings then to an end both our
appeal and cross appeal.
Exactly. Thank you very much.
Thank you very much indeed. Thank you. We'll resume again at 2:00, I think, and when we'll hear from you, Mr. Rossi.
Thank you, Mo.
Thank you very much. Court's now adjourned.